So 25 senators and 176 members of the House filed briefs to the Supreme Court in the New York carry permit case. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you're in the market for something like that, if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, 2 amicus briefs have been filed in the New York State Rifle and Pistol Association v. Corlett case. This is a case challenging the state of New York's carry permit requirements and essentially making it so that individuals cannot get a carry permit in the state of New York unless they show some sort of proper cause, which is a standard that is very hard for most people to meet and effectively makes it so that most people just don't have a carry permit. And this proper cause standard also makes it so that you need to show something more than self-defense. This case is coming out of the Second Circuit, and the Second Circuit actually upheld the state of New York's laws here in restricting carry permits. Then a review was sought by the Supreme Court, and the Supreme Court granted that review, and this is going to be one of the first Second Amendment cases that the Supreme Court has actually granted review on in a very long time. And so 2 different amicus briefs were filed, one by 25 senators, and then the other by 176 members of the House. Now, what an amicus brief is, it is a friend of the court brief. Essentially what it is a non-party individual, a third-party individual, filing a brief to a court, trying to give them additional information and additional evidence about why they should rule one way or the other. Here, the 25 senators and the 176 members of the House are actually supporting the plaintiffs, in this case, the New York State Rifle and Pistol Association, in trying to get rid of this law in the state of New York. So first, let's take a look at the amicus brief filed by the 176 members of the House. And so I'm going to read to you real quick the summary section of this brief. This section states that there is no serious argument that the pre-existing right to keep and bear arms, as recognized and preserved by the Second and 14th Amendments, does not extend beyond the home. But the state law at issue here, New York's infamous Sullivan Law, infringes on that right and effectively eliminates any meaningful exercise of the right outside a person's domicile. The framers of the 14th Amendment intended to prevent states from disarming disfavored and marginalized citizens, at that time, the recently freed slaves. When New York passed the Sullivan Law in 1911, it was motivated by animus against another marginalized group in society, recent immigrants from Europe. For many years, New York has gotten away with barring all but a privileged few of its citizens from exercising their right to keep and bear arms outside the home. And this case presents a chance to right that constitutional wrong. In upholding the Sullivan Law, the Second Circuit incorrectly evaluated the law using intermediate scrutiny. That improper standard of review violated this court's dictate in DC v. Heller, that interest balancing tests are not to be used in Second Amendment cases. The court should reverse the Second Circuit's decision and clarify that the Second Amendment guarantees a fundamental right to carry a handgun outside the home, and that this right is not subject to interest balancing. So the arguments made by the House reps in their brief can be broken down into 3 main categories. First, that the Second Amendment applies to everyone, not just a few privileged individuals. Second, that the New York law here is designed to limit the right to bear arms. Third, that the interest balancing test used by the Second Circuit and other lower courts is inappropriate when you look at the Second Amendment. And finally, that the Supreme Court should affirm the text as interpreted by history and tradition analysis that they outlined in DC v. Heller. So on the first issue, that the right to bear arms applies to all individuals, not just a few privileged individuals, the amicus brief states here that New York's regulation of Second Amendment rights smacks of elitism. It transforms a fundamental right guaranteed to the people into a special privilege to be enjoyed by only an elite few deemed worthy by a government official exercising unbridled discretion. And that's essentially the argument here, that it's so impossible for the average individual to get a carry permit in New York. Essentially, the only people who can get a carry permit in the state of New York are those elite individuals who have proper connections or have some sort of workaround, and it's just not available to the average individual. Going to the second point, that this law was actually designed to limit the right to bear arms, the amicus brief states that the history of the act confirms that it was designed to exclude non-elite immigrants and disfavored minorities from gun ownership. So essentially, the history of this law and the current iteration of this law is all targeted around disenfranchising various groups. To the third point about the interest balancing test not being appropriate when looking at the Second Amendment, they essentially state that Heller and McDonald rejected this whole interest balancing aspect and the use of intermediate scrutiny, especially when looking at Second Amendment violations. And then the next step and the final kind of main argument made in this House of Reps amicus brief is that the Supreme Court should once again affirm the appropriate Heller test, which is text as interpreted by history and tradition. So now let's take a look at the amicus brief filed by the 25 senators to the Supreme Court and the main arguments they made of why the Supreme Court should find that this New York state law is indeed unconstitutional. The arguments made by the 25 senators in their amicus briefs is a little bit more straightforward. Essentially, first they say that the framers already balanced the right and the risk, which the state of New York is putting forward. And the final argument they make is that this is an improper limitation, essentially turning the right into a privilege and a privilege only open to a select number of individuals, similar to the argument made by the House of Representatives in their brief. So on the point that the framers already addressed and reviewed this issue, the senators in their brief state that the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. The enshrinement of constitutional rights necessarily takes certain policy choices off the table. They also emphasize in this section that the right protected is the right of the people to keep and bear arms. This law takes that right of bearing arms and instead makes it a privilege of not the people at large, but only a subset of the people. Now, going to this whole improper limitations, they state that turning to the particular law at issue in this case, petitioners correctly note that allowing only a select few members of the public to bear arms and requiring those few to distinguish themselves from the people in general turns the Second Amendment on its head. They go on to state that New York's policy choice that only those with a severe and distinguishing need for self-protection are entitled to exercise the right to bear arms is precisely contrary to the policy choice made in the Constitution itself to extend the right broadly and to make it a right, not merely a discretionary privilege. And that's one of the main arguments here, is that this is a right of the people to keep and bear arms. It is not a privilege of the subset of individuals. The framers wrote it a specific way to affirm that this is a broad right entitled to all people. So like I said at the beginning, the impact of an amicus brief is a friend of the court brief. It's filed with the Supreme Court. It is used as supplemental information and evidence that the Supreme Court can lean on when making their determination in this case. This is something really interesting because you have House of Representative individuals as well as senators filing an amicus brief to the Supreme Court on a constitutional issue. And this is already a very big constitutional issue because, like I said, the Second Amendment has not been up to the Supreme Court in a very long time. And this is going to have huge and broad-reaching implications when they actually issue their order here. I wish there would have been more senators and reps that actually supported these amicus briefs, but at least we had some that were doing this. Now, what's going to happen is you're going to see, and what we're already seeing is a ton of other amicus briefs are also hitting the Supreme Court docket. A ton of other organizations and individuals supporting both sides are going to be filing briefs to the Supreme Court. And what that tells you is that this is a really big issue. So if you guys have any questions, go and comment down below and I'll try to answer the best of my ability. Also, if you guys like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these types of videos and this type of 2A news, and then it pushes it to more individuals. So even if you guys don't have a comment in mind that you want to drop, just saying, hey, I'm commenting to fuel the algorithm, you'll see a lot of people commenting that. I really appreciate it. It really does help the video, and thank you guys for doing that. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.